remember serving in Embassy London, where I worked on countering terrorism, and in 2015, 2016, as ISIS rose, we had this steady stream of visitors from DC and to DC talking about what are we going to do about ISIS on Twitter, what are we going to do about ISIS on Facebook. By and large, the tech companies realized that there was a groundswell and took proactive measures to prevent ISIS from being so readily available online. I saw yesterday that somebody was searching for IS Khorasan, and they got what is Khorasan, which is a type of grain. So, by and large, these efforts have been sort of successful, right? But what we didn't do is ask important questions about the laws that govern digital and social media. We didn't ask important questions about the limits of freedom of speech and how national security and technological advancement can coexist. So my paper looked at 3 instances in recent history when a tech advancement came up against a national security challenge. The first was during World War I. Amateur radio back at the beginning of the century was sort of similar to the internet that I grew up with. It was very unregulated. I don't think it was very mainstream. And it was scary for intelligence officials, military officers, and law enforcement who were worried about German saboteurs communicating with Berlin in the United States. There's a quote that I found from 1917 that says, U.S. government and police experts were much surprised to find that the cabinet, which was recently seized with Max Wax, a German spy, was capable of receiving secret radio messages from Germany. That struck me because it looked like the sort of headline you would see in 2017 about teenagers communicating with ISIS on Twitter. This sort of hysteria led to a law that was included in the declaration of war on Germany that banned all private radio station ownership. So the government said, we don't understand this, we can't control it, so they seized all private radios. Some people probably wish they could do that today, but that's not going to happen. It's not advisable. We're well past that. But the premise there is that the government saw a national security risk and intervened in the market to do something. The second example comes from much later, and I have to credit one of my colleagues when I was in government from the Department of Justice who said, why don't you just tell them this? Like 5 years ago, and I thought it was pretty clever. So banks, international financial institutions, do not have to report every transaction to the federal government, right? The federal government can request a subpoena or a warrant to do targeted monitoring of individual accounts or persons, but by and large, the system is self-policing. If any of you have ever worked in a bank or know people who work in a bank, they take all of these counter money laundering, counter terrorist financing trainings. Every employee of the bank is responsible for this. And the penalties are pretty severe when banks fail to meet their anti-money laundering requirements. When this was instituted in the 70s, sort of in the age of newly global organized crime, the banks actually took it to the Supreme Court, and they said, this is unconstitutional. You're asking us to spy on our employees. You're asking us to define and provide to the government, or spy on our customers. You're asking us to provide to the government information where we're just a neutral arbiter. People can come to us and they can deposit and withdraw money however they want. This isn't really sort of our role here. The government should be involved. And Chief Justice Rehnquist, in the Supreme Court decision, wrote, no, the banks are not neutral platforms. He didn't say platforms. The banks are not neutral arbiters. The banks have a role, and it's not unreasonable to expect them to ensure that their platforms are not abused for crime or for violations of U.S. national security. So the third example I found was from around the same era, from the era of the skyjackings. There was a wonderful book that came out a few years ago about this era, and what really struck me is that the airlines did not want to impose passenger screening. They were making money hand over fist, and they thought that any additional screening of their passengers would scare people away. One exec told Congress that it would scare the pants off of customers, which is particularly colorful. But until the 70s, you could take guns on planes, you could do all kinds of stuff because the airlines were afraid of scaring away passengers to these early adopters, right, to these new technologies. It wasn't until a hijacked aircraft almost crashed into a nuclear reactor that the Nixon administration finally mandated, with Congress, some form of very basic passenger screening. Now, an interesting thing here around the same time was that the main contention was who's going to pay for this. And the airlines said, well, this is a public issue, the government should pay. The government disagreed. And so airlines put a ticket surcharge, which still exists. You can see it on your tickets when you buy air travel. The premise there was that this was a shared cost, passed on to customers as a tax, but essentially something that the government mandated. So if you look at these three instances, you can juxtapose them with the approach that the government has taken to digital and social media and the existence or perhaps use of these platforms by terrorists on the right and ISIS-backed terrorists, the range. And it's puzzling to me that we haven't, it's puzzling to me that we've allowed these industries to set the limits for their counterterrorism cooperation with authorities and with society as a whole. Now, it's constitutionally, very fraught to suggest any content regulation or, we shouldn't be policing people's speech, certainly. But certainly these companies could be contesting the same range of regulations that advertisers, radio, television contend with. During this era, we didn't see any ISIS Super Bowl ads. We don't see the far right doing radio spots. They're not allowed to, right? So maybe there's some constitutional way to look at our laws that govern this space, which, by the way, were all written like 30 years ago, and perhaps make them relevant for this new age of terrorism.
And please thank all back to join. Are there any questions to open up today? Okay, we've got a couple. Three. Okay, let's start here. So.
Hi, Professor McCord, you made reference to there being kind of a model for doing this kind of investigation in terms of child pornography, that the sort of template is there. But you also made a glancing comment about how ideological issues are a little bit different. And I was just wondering, are there specific statutes that prevent the government from wandering into investigations that might touch on political ideology, or does that fall under the free speech umbrella? Where is that an issue?
So it's not so much a statutory limit as it is internal FBI and Department of Justice guidelines. So for the FBI, it's called Domestic Investigations and Operations Guide, or the DIOG, and there's also AG guidelines that govern what kinds of investigative tools FBI can use. And there's similar internal guidelines for other law enforcement across the country. And in direct response to your question, no investigation may be opened purely based on First Amendment protected activity. And so I think this is something that Director Ray emphasized in his testimony earlier this summer when he said we can predicate an investigation where there's reason to believe there will be violence. So the standard usually, and depending on what investigative tools law enforcement wants to use, they need to have more or less of a predicate for those, depending on sort of the intrusiveness of the tools and the privacy interests at stake and the constitutional rights at stake. So for example, to use the type of undercover operations I was talking about and sting operations, not only could it not be based purely on First Amendment protected activity, there would have to be information to believe that a crime is being or has been committed, right? So this is where we kind of get at the fact that the FBI, to take these steps, needs to be focusing, needs to have a crime at the end of the day. And you can, when you're looking at domestic terrorism and investigations involving far-right extremism that might result in violence, right now they're having to look through other methods. Well, could we open it like as a hate, toward hate crime? Can we open it thinking it might become a RICO violation? Can we open it thinking it might become some other crime? If you actually have a more directly applicable crime, then it helps them to be able to focus their investigations toward that. But they cannot do it based solely on speech. So when we're talking about getting into those kinds of chat rooms and online spaces, there's got to already be reason to believe that the groups are intending to engage in acts of violence, groups or individuals.
So we'll go to the back and then here.
I'll just stand up so you all continue. So I wanted to ask you, like you were just said, Alexander, that you can't be in the business of policing people's speech, but we do when we look at publishing houses as media companies. So can you all comment on Section 230 of the Communications Act and the point that you just made that it has to incite violence? You know, obviously publishing houses are more responsible for their speech, and these social media companies have this cover of not being responsible for regulating speech. And it seems like we do have an answer for it, but can you just let us know where that's at?
Do you want to start?
Sure. So I think that a lot of these companies have taken proactive action in the last few years. That's admirable and should be encouraged, because they know that the tide is changing on this. In Europe, some of these, there are laws that require them to proactively monitor their platforms to remove speech that's illegal there. One gap that I think is perhaps closing or exists is around far-right violent rhetoric. So if you are posting about ISIS, high likelihood that will be identified and removed by these platforms. But where does far right and non-far right, where does the line go between far right and mainstream political discourse? Depends on your politics, I guess, right? So these companies don't want to be in the business of delineating that. To me, that suggests that they shouldn't be they shouldn't be setting the rules sort of at all. That the government should be setting the rules around, sort of like the way they do in Europe. And I think there's probably a way to do it with, while respecting the First Amendment.
Can I just jump onto that? So just another thing to be clear, right? When we're talking about private companies, whether it's publishing houses, whether it's social media companies, they are not bound by the First Amendment, right? So they can actually regulate absolutely whatever they want without running afoul of the First Amendment. I think most social media companies have just respect sort of intrinsically for the principles that the First Amendment embodies, and so they want their platforms to be a place where there's open dialogue and there's, as little regulation as possible, so that there is that marketplace of ideas that's been recognized, by the Supreme Court and by our entire history. But just strictly speaking, they're not bound by the First Amendment. Once you get government regulation requiring them to do things, the government's bound by the First Amendment, and that's why it gets really tricky what the government can do in terms of mandated regulation. And so I think it's important to keep those things separated because, back in 2014, 2015, when ISIS was on the rise, and of course what we saw that was new about ISIS that we hadn't seen with Al-Qaeda was this incredible use of social media in order to recruit, in order to make people feel like the ideologies associated with ISIS and jihadism were actually more mainstreamed and more widespread and more adherents than there really were, and to communicate. And I had a number of meetings myself in my role in the government with social media platforms, along with members of the intelligence community, to brief them on these are how your platforms are being used, educate up. And it took a while, but eventually a lot of the private sector tech sector companies did sort of beef up their own internal review. There was very little of that sort of internal review at the beginning. And then I think what happens is, a couple years later in comes some of the far-right extremist groups doing the same thing, using social media to recruit, using social media to publicize their activities, to encourage violence and even incite violence. That's how Unite the Right was planned over social media, some public, some private chats, and so this has caused the social media and other private sector companies to do exactly what Alex said, and now think, okay, now we have this new threat. How are we going to combat that? And how are we going to combat that in a sphere where it does start to get a little bit closer to some political discourse, at least in this polarized country?
Mark, did you want to add to this?
I'll just add one thing. Social media companies right now are learning what a lot of traditional media companies had to learn in previous generations, which is that while they, leaving aside their responsibilities to the bottom line or to their, to sort of financial responsibilities. They do have a responsibility to contribute to the free marketplace of ideas, but they also have a responsibility to their audience to create a moral or ethical responsibility to create a welcoming environment in which people feel safe and are not fearful of just being on a social media platform. And there's a reason why television stations do not sell airspace to white supremacists. That you're not going to find the White Power Hour, coming in through your local affiliate. And as a result of that, white supremacists have had to resort to other alternatives, like going to cable access television, where nothing could restrict them. Or there's a couple of white supremacists in the United States run for office, not because they actually think they have some sort of chance to win the office, but because they can then go to radio stations and say, I want to place this campaign ad, which is actually a vehicle for racism or anti-Semitism, but the radio stations feel they cannot, because of the FCC, that they cannot say no to someone trying to place a political ad. And so, these are all sorts of things that traditional media have learned in the past, and social media is just now coming to realize their responsibility of not just to maintain a marketplace of ideas, but to also maintain a welcoming environment for their own customers.
So we're going to here, and we'll go next, and then over here. Thank you.
Thank you very much. My name is Peter Studer. I'm the consul of the Russian Embassy here in Washington. First of all, thanks a lot for wonderful presentations, very interesting. But from my point of view, I believe we are kind of missing one part of these counter-terrorism efforts, namely its international cooperation in this field. Because as was said about Islamic terrorism, it's the evil which cannot one country defeat by itself. There should be a cooperation. Only the whole international community can defeat this. I believe we can say the same thing about far-right extremism, because we would take a look at the phenomena, then it's pretty sure we can call it global. Starting from Norway, 2011, going to New Zealand, going to United States, some accidents in Europe. As was said, extremists are using the internet just to propagate their ideas, so it's a global phenomenon. In this regard, I got the following question. What do you think? Could it be useful, even for the American law enforcement agencies, if international community arrange a kind of body, like, for example, like we have in the Security Council with the Counter-Terrorism Committees on ISIS, Al-Qaeda, and Taliban. And this body will be focused on far-right groups. So this committee, for example, designates far-right group, let's say in Canada. Then U.S. law enforcement agencies just have to prove the connection between your far-right extremist here with this terrorist group in Canada, and then you got a terrorist case, not a mass shooting, not a hate crime. It's just the connection between a foreign terrorist organization and the city. And for example, Canada, they designated blood and honor. And as far as I know, there were cases by this group in the United States, in California, if I'm not mistaken. And then the people who killed an American here, they were charged with hate crimes, not with something else. But it could be made like a terrorism case. So can you just evaluate it? Is it feasible to make such a body on international arena?
Excellent. So let's work back down the line. Perhaps we can tie in an additional question or element to that about prescribing far-right groups of the State Department's foreign terrorist organisation list, its implications, and particular implications for states who are supporting far-right groups overseas. Please. Thanks.
Well, first of all, I'd like to point people to a resource that the ADL just recently published on the internationalization of right-wing extremism. We just did a big report in coordination with some of our fellow civil rights and civil society organizations in different European countries on connections between white supremacists in the United States and white supremacists in Europe. And I don't have a URL handy for you. I didn't anticipate this question, but it's easily found on our website, or if you give me your business card, I can make sure that you get it. With regard to law enforcement and dealing with internationally and with international terrorism, certainly the idea of designating certain white supremacist groups as international terrorist groups is something that should be looked at. I do think it's important to recognize the reality on the ground, which is that a lot of the back and forth between such groups, let's say in Europe and the United States or elsewhere, comes either at the level of ideological sharing, sharing of ideas and concepts, like identitarianism sort of merging with the alt-right in the United States, or I mentioned historical examples like the racist skinhead subculture coming from Great Britain to the United States and to the rest of Europe too. And then from the inspiration coming directly from violence. So the Christchurch shooter in New Zealand, who inspired a young white supremacist in California to attempt a shooting at a synagogue in California. And so where there's a gap is the gap between the gap where there's organization or direction, and a lot of international terrorist organizations, Al-Qaeda, ISIS, others, actually exist in a lawless or semi-lawless area where they are relatively safe from being dismantled in the way that countries with a strong rule of law can dismantle extremist organizations that decide to go down a path of criminal activity. In the United States, most organizations that form for the purpose of committing, most extremist organizations that form for the purpose of committing criminal acts to further their cause, end up getting taken apart very quickly. They cannot exist over the long term. And this is regardless of ideology. And so when you look at, for example, right-wing violence in the United States, the vast majority of it is not committed by groups acting as groups. It's committed by lone wolves or small informal cells, 2 actors, 3 actors, 4 actors, or people who may belong to a group but are not doing what they are doing at the behest or at the orders of a group, but in fact may be going off to commit a violent act simply because they're tired or upset that the group doesn't want to do anything. Extremists on the right sometimes refer to that as the meet, eat, and retreat crowd. And so extremist groups in the United States often function more as sort of finishing schools for extremists. They get extremists radicalized, they bring them in, but then extremists themselves are motivated to go off and commit violent acts. And so there's no sort of white supremacist equivalent of an Al-Qaeda or an ISIS, and this makes the issue of designating international white supremacist terrorist groups a little bit more difficult. And I'm not saying there might not be some that would qualify, but it's a lot less easy than some other types of extremism.
I would agree with that, and I think you're very right to call attention to the international nature, and it's just, I didn't raise it earlier just frankly out of time, because I actually think our use of terms like domestic terrorism and international terrorism completely needs to change, and the only reason really we're still using it is because of the way our U.S. code kind of divides things by definitions, because obviously when we're talking about terrorism that occurs in the United States, I mean, that's domestic. So the terms are very confusing, because if it's on in order to further the goals of a foreign terrorist organization, then we call it under law international terrorism, even if it occurs right here in the U.S. So I think that I agree with Mark and with what others have said, and have urged this in some of my writings, that the State Department ought to really be looking carefully at whether any of the foreign organizations would qualify for designation as a foreign terrorist organization. The criteria is ideologically neutral. You must be foreign, because foreign organizations do not have First Amendment rights in the United States. It must engage in acts of terrorism or have the capability or intent to engage in acts of terrorism, and must be a threat to U.S. nationals or U.S. national security. There's 68 organizations on the list right now. None of these are white supremacist organizations. There do seem to be a few that might fit that bill. So the problem is then what would come from that, right? So it becomes toxic in terms of, doing business with, providing any resources or support. So to the extent that anyone who's known to be a member of that organization is, in its own name, or in the organization's own name, engaging in, banking or use of social media, et cetera, that becomes toxic, right? So that takes it down. Now, does that mean it goes away? No, it means that people use aliases and other things like that, right? They don't open their bank account in the name of the Nordic resistance movement. In terms of things like, lone wolfing type of crimes like we see here, the reason I said earlier that if the El Paso shooter had declared Bayat before his shooting, he would probably be charged with acts of terrorism, is not because he was directed by, we're being hypothetical. It's not because I was thinking, well, maybe ISIS directed him to do it. It's because the statute also includes attempts, right? So he is attempting to do something to provide his own support or resources, meaning his own person as a fighter to committing this terrorist act to further the goals of ISIS. So theoretically, you could have those same types of attempts, but it's possibly less likely to be the case when there are already so many groups domestically, right? You don't have to be attempting to do it for the Nordic resistance movement when you can be doing it right here based on your own ideology, whether you're part of an organization or whether you've just been radicalized over the internet. So I agree. I don't think it would necessarily be as useful as a tool to law enforcement as the designation of other FTOs are that don't really have otherwise their own sort of separate existence here. But it's still something I think very much worth exploring. And to get to your point about like the creation of a body, I mean, under our law, under U.S. law, it's got to be the State Department that designates FTOs. But that doesn't mean you couldn't have, like right now, a UN General Council's meeting right now today. And the Global Counter-Terrorism Forum often meets on the sidelines of that. And these are issues that I think these international bodies should be taking up, kind of the way they took up back in 2014, whether more countries should be legislating material support crimes in order, because this was when we were having such a problem with foreign fighters traveling, and so the community of nations got together to really discuss best practices and what they could do legislative and otherwise to combat that threat. So I think those are good forums, and the discussions need to be happening, same as NCTC, our National Counter-Terrorism Center, which has thus far limited itself almost primarily to being the conduit for coordinating and sharing and analyzing information about international terrorism, engaging in foreign government-to-government exchanges. Their mission their mission is capable under their founding authorities of being expanded somewhat to go ahead and facilitate that same type of information sharing, government-to-government, even in the domestic terrorism space.
I would just add, as it relates to the interaction with the private sector, that when the government exercises leadership, be it through formal designations, through an international process, or through less formal sort of convenings, I think the private sector in general responds to that. Something I've heard in conversations is, we don't want to set the rules, we want the system to set the rules for us. So I would think that would be positive, but I agree with both comments.
So can we just have this one question here and one question there? Let's, if you could just both present your questions, and then we'll basically open up for final remarks in response to those. Thank you.
You actually responded to my question with the last response, so if I could just defer my question to my colleague, he has another one.
So if I have Corin's suggestion correctly, well, first, if I have it correctly, so I understood you to be suggesting you make a new statute criminalizing terrorist activity within the territorial jurisdiction of the U.S. That was your plan. So I wonder if the people making the claim about the 51 terrorist statutes already, or statutes already on the books, are using that rhetorically, I take to say that there's issues within the department about how they actually apply it. And I wonder if your suggestion would actually address them or avoid them, given the fact that a lot of terror, in investigations against terrorists, suspected terrorists, are already initiated without a factual predicate. And then also the fact that provided that the attackers or suspects are taken to be jihadi inspired or Muslim, even if they are domestic in any sense of the term, there's actually no connection between them and a foreign terrorist organization. They're investigated, or the investigation was first initiated and then also understood as international terrorism. Given your suggestion, I think that dynamic would still exist or persist. And so I'm wondering how, if that's a consideration, or maybe I'm misunderstanding it, and how would your suggestion address that?
And your question?
Yeah, my question is about personas and the use of personas for open source collections for those who do not possess law enforcement or intelligence authorities. So what's the legal precedence for thinking about that? Is it just the Computer Fraud and Abuse Act, or other things we should know about? What's the current work there? And this is for both the research community and also private sector, since there's a lot of interest in using social media, and people are using it, but what's the legal status?
So maybe we'll work in reverse order, where Alex, Mark, and Mary goes.
So on the question of personas, there are companies that are in the private sector, like mine, that support government counterterrorism missions, and the rules are. It's very difficult because the companies don't want people abusing their platforms, right? They make these rules to keep people from having personas. They want true people with real identities being on their platforms. So I think there are some whitelisted ways for researchers inside and outside of government to use personas in sort of supporting counterterrorism mission. But I don't know that there is a strong set of rules or regulations around that.
To get to that one first, too, each law enforcement agency has its own, criteria, and I also am not familiar with what it is that governs sort of outside government researchers, although I certainly am aware also of those researchers having mechanisms for ensuring that their accounts aren't taken down when they're doing, government research. I don't know if it's effective, but I think those mechanisms exist. To get to your question, so the 51, and I've never actually added them up, I'm just taking as a given that there really are 51. There are a bunch of terrorism statutes in the chapter of the code that's called terrorism, but those are not 51. And then there is a separate definition of federal crimes of terrorism that lists a whole bunch more. And they're very, very specific. Things like use of a weapon of mass destruction, use of like a biological or nuclear or radiological dispersal device, shooting down airplanes, attacks on mass transportation, attacks on U.S. government officials. So they're very specific, and none cover this mass shootings that we've been talking about, the most common types of terrorism. And so I do think sometimes that point is made rhetorically to suggest, look, we have ample authorities right now, and the FBI is just not using them. They're just choosing not to use these in order to open these cases. They're not prioritizing them. But in fact, most of those statutes wouldn't be applicable to what we see the most commonly. I will see some of the sting operations that we have seen that have involved what have been commonly thought of as domestic terrorism. You mentioned Garden City. Are cases where it's been, someone talking about building a bomb in order to attack. The Garden City case involved a plot to bomb a Muslim apartment complex and mosque, and it was basically three, white nationalists that were involved in that attack, and that plotting, and that was taken down as a result of a sting operation, and it was able to be done so and charged with terrorism crimes because it involved weapons of mass destruction. So I think in a way that's a little bit of a red herring discussion, but to your point about, I think you said a lot of investigations are open in sort of the international terrorism rubric without any facts. That might be what people in the public think, but the dialogue really does require, for every level of investigation, a predicate, and the predicate rises. By predicate, I mean predicate facts to support that a crime is being or has been committed, and the predicate market rises depending on the tool to be used, from just open source, looking out at internet versus like getting in an undercover. And so I know the perception is out there that a lot of times that is not the case, but those guidelines already do apply within the Bureau and the Department of Justice, and DHS has its criteria as well. Certainly our foreign intelligence collection agencies don't have authorities domestically except in extraordinarily limited circumstances. So I think that you're right that there is a fear in the civil rights, civil liberties community that the same thing would be done if there were a new statute that applies to acts of terrorism domestically, and there's concern that, I've heard it stated, we don't like the current regime, why would we want to create another regime that's like that? So I would just go back to, there are predicates that are required. The EPA doesn't have to announce to the world what those predicates are when it opens investigation. It would sort of ruin their ability to investigate, but those do exist and they would exist in this regime. And I don't see Congress rolling back the current CT regime. So if we're going to get some sort of equivalency and try to use the similar tools, it's probably not going to be by repealing existing C2, the current threat picture.
And the final word, Mark?
With regard to your question, I just want to make one small point, which is that regardless of what overall structure there might be, a lot of the people who would be investigating potential domestic Islamist extremist terrorist activity would be doing that. The same people would be doing that under whatever structure. And one of the reasons why domestic Islamist extremism criminal acts or potential criminal acts are investigated by the IT squads of Joint Terrorism Task Forces is simply because that's where the language skills and some of the other technical skills that may be necessary to do such investigations reside. So there are practical reasons, in addition to other reasons. I do want to make one general point about domestic terrorism, and that is, in contrast to international terrorism, we have a much less complete infrastructure for dealing with domestic terrorism. We have a partial infrastructure for dealing with domestic terrorism. Now, the part that we have is really good. We have joint terrorism task forces across the country that have federal, state, and local law enforcement officers cross-deputized, working together in the same place to be able to share intelligence, to be able to work the same cases, and they are, on the whole, extraordinarily effective. We also have fusion centers, we have informal working groups. Some AG's offices have their own groups too that bring together people from different agencies and different levels. But there's stuff that we don't have that we need to have. And I just want to mention two particular pieces of proposed legislation that would help to complete or make more complete our infrastructure to allow us to deal with domestic terrorism. One of those is the so-called DATA Act. And it's a mouthful. It's the Domestic Terrorism Documentation and Analysis of Threats in America Act. And this would have the FBI produce an annual unclassified joint report on domestic terrorism, have the Government Accounting Office audit it, and have other similar related measures so that the public is given an understanding of what the domestic terrorism situation is on a regular basis, an awareness that we don't always have right now. And it provides more transparency in terms of collective efforts and data collection, and allows us to identify problems for which we need to arrive at solutions. And the second thing, sort of extending that, is the Domestic Terrorism Prevention Act, the DTPA. And this would enhance the federal government's efforts to deal with domestic terrorism by creating offices, specific offices addressing domestic terrorism, and requiring federal law enforcement agencies to regularly assess those threats. It would provide training and resources to non-federal law enforcement in addressing these threats, making sure that DOJ, DHS, FBI provide the training and resources. It would reauthorize the Domestic Terrorism Executive Committee, which was originally created after the Oklahoma City bombing but was allowed to lapse. It would create an interagency task force to explore white supremacist activities within the United States Armed Forces. And it would require a joint report by the offices that it created and other authorized offices that would inform relevant committees of domestic terrorism threats and what has been done to counter the threats. And this bill then ensures that resources for those agencies are tied to threats, including law enforcement resources that are being used, making sure that law enforcement agencies are not being used against non-violent extremist groups as well. And passage of these acts or acts like them, would add more pieces, make our infrastructure that is required to effectively deal with domestic terrorism, and in particular to prevent the horrific acts of domestic terrorism and hate crimes that we've seen in the past few years, much more complete than it currently is. I work very closely with law enforcement at the federal, state, and local level. We have a tremendous number of dedicated law enforcement officers from the FBI on down trying to deal with this problem of domestic extremism. But we can do more to support those efforts. And so the Data Act and the DTPA are good acts that can help do that.
And please thank the speakers.